Hi, my name is Rebecca Goldfrank, and I'm the Director of the Family Permanency Project at the Children's Law Center. Today I'll speak with you about the role and practice of being a guardian ad litem in domestic relations proceedings. Being a guardian ad litem, frequently referred to as a GAL, is a unique and rewarding role in the adversarial system. It's an opportunity to work directly with children and families and help shape their lives. What is a guardian ad litem? In the District of Columbia, guardians ad litem must be lawyers. The DC Code specifically states that the court may appoint a disinterested attorney to represent the best interests of the child. This attorney does not necessarily represent the child's stated interests, and that is why this is such a unique role. Significantly, there's no funding stream available for guardians ad litem in custody cases, and that's why pro bono attorneys who do this on a volunteer basis are so important. There's a tremendous need for advocacy for children in the District of Columbia, and particularly in custody cases. In the District of Columbia, there's no statutory definition for the role or the duties of the guardian ad litem. There has been some guidance from the Superior Court on this practice. There's a lower court decision called Meekins versus Corbett that provides some information. There's also a case called SS versus DM, and that is in the neglect context. And this case affirmed that the principle that an attorney, including a guardian ad litem, should not serve as an advocate and a witness in the same proceeding. So why do judges appoint guardians ad litem? These are very emotionally charged cases. Custody cases typically are. Nearly 80% of the litigants in custody cases are unrepresented, and so there isn't the buffer of an attorney to couch the issues that are presented to the court. Frequently, the parties appear before the court and they are each saying completely contradictory information, and the court simply has a very difficult time discerning what is the truth. Therefore, the court will appoint a guardian ad litem. The court hopes that the guardian ad litem will help reach a decision prior to or at trial. There's a helpful handout in tab 1 that's practice pointers for guardians ad litem, and this should guide your practice. It is also a good idea to print out the table of contents for the manual, which you will receive on disc from Children's Law Center. The manual has a wealth of information that can also guide your practice. The court may also appoint a guardian ad litem to improve communication between the parties and to reduce time in court. The reality is that the domestic relations judges have a significant caseload, and that parties are frequently unable to get before the court in the amount of time that they would like to. So it's often beneficial for the parties and certainly the children to try to work things out outside of court. The guardian ad litem will often come into the case with a fresh set of eyes and fresh perspective on the issues that the family is dealing with and can help bridge the divide between the parties. The GAL, relatedly, may also help get the parties into mediation or facilitate settlement talks. The court could also want to learn more about the child in an objective manner. Again, the parties have been before the court and they've represented to the court various different things about the child's needs, about the care being provided by the other party, and the court simply doesn't have the resources available to figure out what the truth is. However, the guardian ad litem, in her role as an investigator, is able to do so. The judge may also want to appoint a guardian ad litem as someone who can present to the child a better sense of what is going on with their case. Often the children are very much aware that there is ongoing litigation regarding their custodial arrangements, regarding their parents fighting, or their grandmother and mother fighting. And so it's important that the child have an understanding of the court process, assuming that it's developmentally appropriate. Obviously, you wouldn't talk with a 3-year-old about the court process, but the child is entitled to know what's going on and may benefit from having a more neutral person relay that information. Sometimes judges will appoint us for a very limited purpose. For example, the child may be in need of an individualized education plan, referred to as an IEP, and the parents, in the court's view, may not be adequately advocating for these child's needs, and so the court may request that a guardian ad litem investigate the child's school situation. Another example is that the court may be dealing with an older child, and the court may have questions as to whether the child should testify. And so the guardian ad litem may be appointed to investigate that issue. GALs are also sometimes asked if they can assist in locating services for the family, such as obtaining therapy or family therapy or tutoring for the child. So now we'll move on to getting started with a guardian ad litem case from the Children's Law Center. First, Children's Law Center will send out an email listing all available custody guardian ad litem cases. This email list typically goes out every 2 weeks, and it will have a case description, a very generic case description. Upon reading a case description that you are interested in, you should contact Children's Law Center to let us know which case you'd like to take. In response, we will then send you an email with the case name, case information, and contact information so that you can run conflicts checks. This is the same information that we'll have received from the court on the case referral sheet. When we provide you with the case information, we will also provide a sample appointment order. It will be necessary for you to prepare the appointment order and email it to the judge's clerk. It's important to note that your duties and responsibilities do not begin until the judge signs the appointment order. Once you've received your appointment order, you should file your precipice of appearance. And in that initial email from Children's Law Center, we will have provided you a sample precipice of appearance. And once you've done those things, you should contact counsel for the parties or the parties themselves if they are pro se. Those are the beginning steps. And in the next series of slides, I'll turn to the duties and roles of the guardian ad litem. As mentioned earlier, there are no standards of practice in the District of Columbia or definition for what a guardian ad litem's role is. The following slides that I'll discuss are rooted in the American Bar Association Standards of Practice for GALs and also in the Maryland Standards. An important role for the GAL to maintain is that of independence. The guardian ad litem shall be independent from the court and other participants in the litigation and unprejudiced and uncompromised in his independent action. That means that the guardian ad litem is not simply an arm of the court, but must exercise independent judgment, and is free to participate in the case as any other lawyer for any other party. A lawyer appointed as a guardian ad litem shall not testify as a witness, but shall offer traditional evidence-based legal arguments, exhibits, and witnesses in accordance with the laws of evidence in D.C. The GAL shall also make appropriate motions, evidentiary objections, file briefs, and preserve issues for appeal. The GAL shall also respect parental autonomy without imposing her personal belief system on the parties. So that means that a parent may not parent as you would. However, that doesn't necessarily make that person a bad parent. It's important also to remember that the GALs have no authority over the child. The GAL may not sign an authorization for the child, may not consent to an activity on behalf of the child, and those are the rights that are maintained by the parents or any other legal custodian of the child. The GAL must also ensure that the child's position is made a part of the record if it's appropriate. It's important that when representing a sibling group, that the GAL inform the court whether the children have differing views on whatever issue is before the court. Another important issue that comes up frequently in our cases is whether the GAL should report an issue to Child Protective Services. It's critical to note that the GAL is not a mandatory reporter of abuse or neglect. And we ask that attorneys who take cases with us feel free to contact us if this is an issue that comes up on their cases. It may well be appropriate to contact child welfare, but it's also important to weigh the varying issues that come up in such a circumstance, because a call to Child Protective Services may set in motion a chain of events that just can't be undone and may have a profound impact on the child. Critically, the child's safety is paramount. However, this is a consideration, a significant consideration, and we ask that you contact us. The GAL shall also be sensitive to cultural, racial, ethnic, or economic differences among the attorneys, parties, and the child. The GAL also has a duty of continuing an independent investigation. And during this duty of investigation, the GAL must be aware and sensitive to how his or her actions may impact the child's well-being. For example, if the GAL were to repeatedly appear at the child's school, this may be something that is very embarrassing for the child. It may still be necessary that the GAL attend school or visit the child at school, but it's important to consider how to do so discreetly. The GAL shall also monitor the implementation of court orders and address any non-compliance. A critical role for the guardian ad litem is investigation. And we'll talk now about some of the very beginning steps of that investigation. At the DC Superior Court at 500 Indiana Avenue on the JM level in JM 300, which is the clerk's office, you may obtain a copy of the court's docket and also the case file. The docket should immediately be available upon request. It's a computer printout. However, a request for the case file may take some time, as the file may be lengthy or it may be in chambers or otherwise not immediately available. It's very important to review the docket and the case file to get a sense of the procedural history and all of the issues that have come before the court. Another important step to take at the beginning stages, not necessarily before meeting with the parties, but is to search for any companion cases that may be ongoing or may simply be part of the history of this family. All of the court's clerk's offices, except for the neglect clerk's office, is accessible to the public. Therefore, you can go and check whether there's been a child support proceeding or a civil protection order case. And it may be necessary for you to attend hearings in these related cases, perhaps simply to gather information that you wouldn't be able to glean from reading the court file. You will also want to perform background checks on the parties, and in tab 7 in the manual, there's helpful information about how to do so. You can run criminal and civil checks on the parties, and perhaps also any other adult individuals in the home that the child may be living in or visiting. You can also investigate domestic violence cases. The clerk's office in DC is open, and you can pull those records and can often find very helpful information. It's also important to run criminal and civil records checks in other jurisdictions where the parties may have lived. Frequently, we live in a small metropolitan area, so we always run checks in DC, Maryland, and Virginia, but you should also check any other jurisdiction where the parties have resided. In terms of investigation, you may need to interview collateral witnesses. So for example, you might want to talk with the child's teacher or administrators or the guidance counselor. You may also want to talk with the therapist, other family members, the neighbors. And during the course of your investigation, while you're interviewing these people, it's important that you do not disclose information about your investigation. Typically, these cases have been ongoing for some time. If the case hasn't been ongoing, there's been tension that many of the people involved in the child's life may be aware of. It's important that you maintain confidentiality and don't unnecessarily disclose this private information that could have a negative impact on the parties or the child. Another important step that you must take as a guardian ad litem is to explain your role to the child client. Once appointed, promptly contact whomever the child lives with to set up a visit. If it's in the child's best interest and developmentally appropriate, the GAL should explain to the child about the court system, the court proceedings, the GAL's responsibilities, and that the GAL will do several things, including investigating and advocating for the child's best interest, discerning what the child's views are, using information from the child to further the child's best interests, and not always will the GAL necessarily advocate for what the child wants. If the child's wishes differ from the GAL's position, the GAL must inform the court of this discrepancy. Often, the child's stated interest will heavily shape the GAL's position. It's important to recall that children will vote for their feet. However, it's not necessarily the paramount consideration. Another important role of the guardian ad litem is to build a relationship with the child client. This may mean getting on the floor and talking with the child, or it may mean visiting the child on several different occasions. You must keep in mind that the child is not immediately going to open up to you. You are a stranger, you are an attorney, you are explaining complicated issues to the child. So it's important to consider when going to speak with your child client how you appear. Are you going to go dressed in a suit? Probably not, but you could put on some jeans and be prepared to sit on the floor with the child, or go for a walk with the child to the park if the parent allows you and the child is comfortable. The following slides look at some of the questions that you might consider asking your child client. It may be that these questions are not all appropriate for your child, and you have to consider the child's developmental age and maturity level when deciding what sort of questions to ask. It's important that you don't barge into your first meeting and ask the child who he or she wants to live with. This child has been likely in the midst of a very contested custody battle, and that's simply not appropriate and not the best way that you would learn the child's wishes. It's not unusual that our clients have been prepared to meet with you. In one instance, we've had a 5-year-old who told us that he only wanted supervised visits with his mother. Sometimes things are just not credible, and it's important that you ask the appropriate questions and build in time in your representation to build a relationship with your child client. Some questions that you might consider asking the child are who takes him to the doctor, or who takes him to the school, and what kinds of activities does he like to do, and who he does them with, or who makes his meals. But you're asking open-ended questions that will help forge your relationship and also help you get a sense of your child client. The responsibility to communicate with your child client is an ongoing responsibility. You have to keep the child abreast, again, if this is developmentally appropriate, of the proceedings and where things are, and stay open, have open lines of communication with the child client. Next, we'll turn to some valuable tools and resources that are often used in custody cases. These tools can be requested by the guardian ad litem, or they may be requested by one of the other parties, or they may have been ordered sua sponte by the court. The first important tool that is often ordered in these cases is a home study, and the home study is conducted by the Court Social Services Office at DC Superior Court. It's typically conducted by a probation officer who will set up a meeting with both of the parties to the case and will ask to observe the child in the presence of both of the parties at their custodial home. The home study officer, as an initial step, will do background checks on any of the persons over 18 in the home, will conduct an interview of the party living in the home, and will also do an inventory of the home. So they will look at the kitchen, and they will look at the bedrooms and assess whether there's adequate bedding, adequate food, adequate hygiene supplies. These home studies can be a very useful initial tool. It's important to note, however, that typically the wait list for home study completion is about 9 weeks. Another important tool available to the court and the parties is a psychological or psychiatric evaluation of the child, of the parents, or any of the caregivers. These must be court-ordered studies, and they're performed by psychologists or psychiatrists who contract with the assessment center, which is an arm of the court. These are considered forensic evaluations. At the very beginning stages of these evaluations, the evaluator will inform the parties that the evaluation will not be confidential because it is for court-ordered purposes. And these evaluations can provide very useful information about the parent's strengths and weaknesses, or whether the child is having any cognitive delays or any issues, or what are the foremost emotional challenges for the child. Additionally, the assessment center may perform an attachment or interactive study, sometimes also referred to as a custody evaluation. And these studies evaluate the interaction and the relationship between the child and the parents or the caregivers. The interactive studies will take place over several hours. The psychological or psychiatric evaluations typically take 2 to 3 hours. Another useful source of information are the supervised visitation center records. If one party has been ordered to participate in supervised visitation with the child, it's typically done through the supervised visitation center, which is an arm of the court as well. Those records can be made available to you upon request. Typically, a social worker observes the visits and will take notes on the interaction between the child and the parent. Another great tool that's available through the court is the Office of the Parenting Coordinator. And although this is a limited resource, we found that it's been very useful on many of our cases. The parents, both parents or both parties, must agree to participate in the program. And basically it entails working closely with the psychologist toward the goal of effective co-parenting. Next, we'll turn to pretrial responsibilities of the guardian ad litem. The guardian ad litem must conduct a thorough, continuing, and independent investigation, including engaging in discovery if appropriate. The position of the guardian ad litem may change over the course of the case. These cases are alive, and circumstances in the child's life may change. And so it's important that the GAL stay very aware of what's going on with the child and the parents, and to continue in actively investigating the case. The GAL should also develop a legal theory and strategy of the case, and stay apprised of any other court proceedings affecting the child, the parties, or other household members. For example, when you first get the case, you may be aware that there's a civil protection order in place that might bar the father or the mother from contacting one or the other. Stay abreast of whether that CPO may have been violated. The parents may not necessarily tell you that they've violated a CPO, but it is of public record, and you should make sure that you're aware of that information. Additional pretrial responsibilities include attending meetings involving issues within the scope of your appointment as the child's guardian ad litem. The GAL should also take any necessary and appropriate action to expedite the proceedings if appropriate. And the GAL should also participate in, and when appropriate, initiate negotiations and participate in mediation. Mediation can be a very effective tool, and it's continuously available and free through the multi-door services division at Superior Court. Further pretrial responsibilities include participating in depositions, pretrial conferences, and hearings. The GAL may be the party who needs to initiate a pretrial statement, particularly if the parties are both unrepresented. They may not be aware of how to begin a pretrial statement, and your doing so will help move the case along and will help narrow some of the issues and make sure that the parties are only presenting relevant issues before the court. The GAL should also file motions or responses and oppositions to any pleadings and make objections when necessary. The GAL should also take a position based on the child's best interests regarding whether or not the child should testify and file any necessary motions to advance that position. This issue of child testimony may not come up in every case, but it's important that the GAL be aware of how to protect the child during that stage. In terms of going to trial, it's important to start preparing early. You should plan to call witnesses, enter exhibits, and put on evidence which supports the GAL's position. Think about who you will call as a witness and make sure you subpoena those witnesses. It's important, particularly with expert witnesses such as the evaluators who may have conducted the psychological or the interactive assessments. It's important that you put those people on notice of your trial date as soon as possible. They're very busy professionals and appreciate the notice. You should also prepare all your witnesses and interview other parties' witnesses as appropriate. The GAL's responsibility in terms of child testimony or interview with the judge is to minimize any adverse consequences to the child of such action. If a child is to meet with the judge or to testify, you should take the child down to Superior Court so that the child has a sense of where he'll be going. And certainly you could take the child into a domestic relations courtroom so that the child could have a sense of the environment in which the child may have to testify or talk with the judge. This can be a very traumatizing experience. It's not to say that it will always be traumatizing. For example, in one case we had a 17-year-old girl who just simply wanted to testify, and she was prepared and it was developmentally appropriate, and it was not at all traumatizing. But it's important to keep in mind that there's a spectrum of responses. After trial, a final written custody order will be entered, and if any party will be appealing, they have 30 days to file a notice of appeal. That's 30 days from issuance of the final order. Please refer to Domestic Relations Rule 101E4 regarding when the GAL's representation ends. It is usually CLC's practice that we file a precipice indicating that our appearance has ended 30 days after a final order has been entered. It's critical that the GAL speak with the child about the end of the representation if this is a developmentally appropriate topic. It's important that the child have a sense of closure at the end of the case. There's a tremendous need for advocacy for children in contested custody cases, so thank you for taking the time to listen to this discussion of the role and responsibilities of the guardian ad litem.